Start with that very widely read story this morning about Michael, who was going on a long journey in his car. All of a sudden, he got a terrible urge to go for a wee. So he found a lay-by and he pulled over, but was very shocked by what happened next.
Returned to the car. All of a sudden, there's a knock on my window, the driver's side window, and there was an enforcement officer there who gave me an £88 fixed penalty notice. For littering.
For littering?
For littering. He said that what I did was now classed as littering.
What, having a wee?
Yeah. Anyway, I was very apologetic to him. I explained to him, I'm ever so sorry. You know, if I'd have gone any further, I would have soiled myself. It was an emergency. I'm a 70-year-old man. I do have a weak prostate. And I couldn't do anything. I had to stop. Luckily, the lay-by was in time for me. He was not at all sympathetic. He was very polite, but he was not at all sympathetic and issued me with a fixed penalty notice for littering. £88.
Well, Michael was livid, and that's why he called into my programme and asked for some help. I promised him we would go off and have a word with the council, and we did just that. Michael's back on the JVS show now. Hi, Michael.
Good morning to you, Jonathan.
Good morning to you. Now, as you know, when I went off to speak to the council concerned, it's Dacorum Borough Council, their initial response was as follows. They said that you, Michael Mason, were issued with a fixed penalty notice by a district enforcement officer on the 21st of November 2023 after witnessing littering on the A41 lay-by. We work in partnership with District Enforcement, a company that specialises in enviro-crime enforcement, to issue fixed penalty notices for littering and breaches of our public space protection orders. District enforcement officers patrol public places in areas where littering is prevalent and are instructed to issue fixed penalty notices once they've witnessed a littering act. The legislation relating to a littering offence states that a person is guilty of an offence if that person throws down, drops, or otherwise deposits and leaves anything whatsoever in such circumstances as to cause or contribute to or tend to lead to the defacement by litter of any place to which this section applies. Now, this is very important. Urination, they say, is classified as litter by the Environmental Protection Act 1990. Now, they then went on to say that they didn't know about your prostate problem. They said that had they been made aware of it, then, of course, they would have looked again at this. So you obtained a letter from your doctor to show that you do have what you describe as a weak prostate. And that letter was sent off to District Enforcement and they cancelled the fine, didn't they?
Correct.
Which was great. That was great. That was a tremendous success. And we were very grateful at the time that, if you recall, a friend of this programme, Nick Freeman, the lawyer known as Mr. Loophole, joined us on the programme. He offered his legal perspective on all of this. And what was very crucial from what Nick was saying, and he's back on the JVS show this morning. Good morning to you, Nick.
Good morning, Jonathan.
Morning. You were saying, and this was the crucial part, that urination is not described, it's not litter, and there is no part of that legislation, the 1990 legislation that they refer to, the Environmental Protection Act, that talks about urination being litter. So therefore it was unfair and unreasonable to use that legislation against Michael. Now, when Michael appeared back on the programme and explained that he was very happy, obviously, that his fine had been cancelled, you raised the very interesting point, didn't you? That this, of course, was good news for you, but how many other people have been fined using the same legislation?
Exactly.
And you said, I think we need to go back to Dacorum Borough Council. So I went back to Dacorum Borough Council again, and they came back with this. They said that Michael did not mention any medical conditions in his representation or dispute of the fixed penalty notice or other defence for his actions. But since learning of all the facts, we're pleased that in this case, the FPN has been rightly cancelled. Now, they then went on to say, and this is very crucial, with regards to comments from your guest, the lawyer Nick Freeman. The definition or classification of urination as litter or urinating in public as a criminal offence under the 1986 Public Order Act is not for us, as an individual borough council, to comment on or define, but best put to the appropriate national level representatives if this is something you want to pursue on your show. Now, I forwarded that on to Nick Freeman, the lawyer known as Mr. Loophole, and Nick, you weren't very impressed with that, were you?
Not really, Jonathan. I don't think you were. Michael probably isn't either, and all the other people who have had a wild wee in this layby or anywhere else. I mean, the council's made the right decision. It's important to bear in mind this is a criminal offence. So what we're talking about here is something quite serious. We're talking about having a criminal record for having a wild wee. So it's very important that it's dealt with properly. And the council pursued this prosecution by way of a fixed penalty against Michael under Section 87 of the Environmental Protection Act, which criminalises the offence if it's made out. The offence is basically what you and I and everyone else knows as dropping litter, discarding litter. That is what the offence is about. And the Environmental Protection Act very helpfully goes on in Section 90 and gives a definition section. And when we have a statute, what we normally do is we use the ordinary words, the ordinary understanding of what litter is. And I think we all know what litter is. And it goes on by way of interpretation to say it includes things like chewing gum and cigarette butts and cigar butts and those sort of things that are commonly displaced out of cars or by people who are walking. And that understandably is litter. And that is the basis of this prosecution, and I'm very confident that is the basis of every single person who has been prosecuted for having a wild wee in this particular area. And it simply, as a matter of law, under the section that they have pursued, it is not litter. And therefore, people have been fined or given fixed penalties for offences that they have not committed. You cannot pursue and convict somebody and obtain money from somebody if you do it under an erroneous piece of legislation. That is what they've done. They've tried to sort of stretch this particular piece of legislation and squeeze it into urine being litter. And there is not in the wildest of our dreams, urination cannot ever be described as litter. However, and I did say on your show last time, there is an offence of spitting or urinating in a public place, etc., and that's contrary to it's the Public Order Act, Section 5, 1986, and that situation, that legislation, the spirit of that is designed to deal with people who get drunk, who behave in a disorderly fashion, and spit, urinate, and even worse than that, in public places, normally because of under the influence of intoxicants or drugs. And it's to quite rightly rule out that behaviour. That is a completely different piece of legislation, and there are other components to that charge, because people need to be offended, they need to be insulted. There are other ingredients that need to be satisfied. There's not the slightest hint that legislation has been used in terms of Michael's case, or I'm guessing, and I'm very confident I'm right, in anyone else's case in Dacorum Council. So they've been disingenuous when they start referring to legislation that I brought up on your programme, which could potentially criminalise urinating. It could do if there were people who were standing by and you were basically exposing yourself and causing a public nuisance and behaving in an inappropriate way. And the legislation makes complete sense. And I'm sure all your sensible listeners will think, absolutely, that is not a way to behave. That is a mile off from somebody who's driving down the road. And it's important to bear in mind, there are 12 million pensioners now in this country, Jonathan. And most men of a certain age have an enlarged prostate. And the symptoms, as Michael's doctor rightly says, is all of a sudden you have this urge and it needs to be dispensed with quite rapidly. And you know, the law isn't stupid. It's designed to accommodate people. And in any case, you know, he would have a defence in any case, even if they've got the right section. The point here is urinating is not litter. The council now are trying to move the goalposts and talk about different legislation. And what we really need to know is how many people have been fined for urinating under Section 87 of the Environmental Protection Act. And in relation to those people, over say, a period of 10 years, would you agree to refund all the fines that you've received, because those fines have been unlawfully received? And if they won't do that, then hopefully all your listeners, and obviously the media are now interested in this story, and it's a story which affects many, many people, will think, I'm now going to contact the council, and I would invite them to do so if they have been fined or received a fixed penalty for having a wild wee in an outside area, provided they've been doing it discreetly and appropriately, because they are entitled legally to a refund.
Right. So every single person, in your legal view, who's been given a fine should request that the return of that fine. And I presume that's for everyone that's been fined by Dacorum Borough Council. Now, I know there are also some other councils, including some here in Beds, Herts and Bucks, that have also apparently been fining people under the same legislation. Should the recipients of those fixed penalty notices also ask for their money back?
My message, if it doesn't sound arrogant, should go across the country to every single council who has fined somebody for having a wild wee, let's call it that, in a public place under the particular circumstances that we're talking about. That doesn't mean that any member of the public can simply go about and stop wherever and just have a wee. That's not what I'm saying, and I'm sure your listeners understand that. But in any event, it's not litter. It simply isn't litter.
Now,
and the other aspect, Jonathan, it's a very serious aspect. All these people, well, it depends whether they've had a fixed penalty. It's a criminal offence. So some people may have been through a tribunal or court, and they will now have a criminal record, which is actually really serious, because they might think I'm of good character. Not necessarily.
Now,
Section 87 is a criminal offence. It causes a criminal offence to be committed.
We have approached Dacorum Borough Council again. They have come back. This is the latest statement that we have from them. They say district enforcement, and it's worth just remembering that district enforcement, I believe, is a private company that provides the services to not only Dacorum Borough Council, but there are also some other councils around the country that use their services. Yeah. They say district enforcement has been contracted by the council after a tender process to provide the council with enforcement for littering and public space protection orders. They also support the council with proactive initiatives such as hot spot monitoring, responsible for dog ownership advice, leafleting in areas where there have been known problems, handing out stubby cases for cigarette ends, and acting as a visual deterrent for those considering environmental crimes. Prior to implementing this initiative, the council sought expert legal advice from specialists in all aspects of local authority, regulation and enforcement, from envirocrime and ASB, through to planning enforcement, licensing, food and health and safety. This included advice on urination. The same specialists provide advice to national projects such as Keep Britain Tidy and the Keep Britain Tidy Network, as well as Tidy Northern Ireland and Keep Wales Tidy. The council recognises that there may be circumstances where representations or challenge are made against fixed penalty notices, with the first stage heard by district enforcement and the second stage by council officers. In the case of urination, if medical advice is provided, the fixed penalty notices are withdrawn, as was the case with Michael Mason.
Well, the main issue I have is they're proceeding on a false premise, and they don't seem to acknowledge that. They don't seem to understand that urination is not littering, and it is as simple as that. And everything they're trying to achieve is excellent, because we all want to live in a cleaner environment. We don't want people dropping litter, except we want people to behave properly. And all that is commendable. But at the same time, as a lawyer, if they are going to fine people, punish people, and they've got it right, and they've issued a fixed penalty, they've specified the statute, they've got to get that bit right as well. And they've got it wrong here. And they've proceeded under the Section 87. It's defined or interpreted more accurately under Section 90, and urination is not litter.
Now, if the fines have to be repaid, Obviously, that's potentially, we're not sure at this stage how many people have been fined using that particular piece of legislation. That's something that we are trying to establish at the moment. But it's likely to be very costly for councils to have to repay people. Would it be down to the council, or would district enforcement, the company that ultimately gave out the fixed penalty notices, would they be liable for the refund?
Well, I'm not sure who trains district enforcement, and I don't know they're basically subcontracted to do a job, and I think they're incentivized in terms of issuing notices and raising revenue, and they're paid well for it. Clearly, they have got it wrong, but I anticipate at the end of the day, they're acting on the instruction of the council. The legal advice will come from the council. And we've heard reference to the legal expertise and specialist legal advice that's been sought in this regard. And generally, it may be right. It's not a discrete point, it's a very simple point. Litter is not urine, or urine is not litter, and it can never be regarded as litter. And that's quite distinct from an offence under the Public Order Act. We're not talking about that situation. We're simply talking about someone who has a wild wee. They cannot be prosecuted under Section 87 of the Environmental Protection Act for several reasons, but the fundamental reason is urine is not litter. And it's that simple. So, I stand by my point that all those people who have received financial penalties under this particular section, irrespective of whether it was an emergency or not, should be refunded, because you cannot have any corporate entity, any legal entity, which imposes a financial penalty when they do it under the wrong legislation, and that's what's happened here.
Nick,
you can't wrongly criminalise people. It's very important. That's why we have lawyers, Jonathan.
As always, thank you very much indeed for your time. We will now monitor this. We will see what happens. We will try and find out how many people have been fined using this legislation. I will request that all of my listeners who have been fined, and we know there are others because they've contacted this programme to let us know that they've been fined in the same layby on the A41 in Hertfordshire. So for all of those people, we would advise them to write to the council and to request their money be returned to them. And if that money is not returned, what next, Nick?
Well, there are a variety of options, and one, of course, is legal recourse. But to pursue that, the answer is, first of all, to pursue legal recourse. But of course, there's a cost implication involved in that. And I think it's a case of, first of all, finding out how many people are involved. I wouldn't have thought there were going to be that many, and I wouldn't have thought it will be that much of an expensive exercise for the council to do the right thing. But I don't know. It's not like sort of driving in a bus lane or something like that. But to answer your question, if the council, it may be that people have been fined, and maybe that some people have just said, well, I had a medical excuse, because it's quite clear from Michael's case, the enforcement officer's not done his job properly in terms of recording the conversation. He sort of almost arrogantly says no mention was mentioned, no mention was made of the medical condition, which is a complete lie. And as I think I said last time, what ought to happen, and I hope your listeners take note of this for the future, when you have a conversation, whether it be with a police officer or somebody official, and that conversation is relevant to the offence, you ask them, would you please write it down? I'd like to read it, and I'd like to sign it to confirm its veracity. And that way we don't have a situation where I told you, no, you didn't. It's there in black and white, and it's vital, and the law actually, the Police and Criminal Evidence Act enables that to happen, and that's what should happen, so that there's never an argument about who said what. So certainly moving forward, that's something that your listeners can take notice of. It will help them in the future if they ever have any occasion to be involved in this sort of incident or incidents involved with the police. And quite often, police will make a note and actually ask you to read it and sign it. That's what should happen.
Nick, thank you very much indeed for your time. There's Nick Freeman, the lawyer known as Mr. Loophole, who's kindly given us more of his time this morning on the JVS show. So